Welcome to today's program entitled Navigating Wage and Hour Risks Under the Biden Administration. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down as it will not be reread and is required for CLE credit. Copies of the webinar recording and materials, along with the CLE attendance form, will be distributed to attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. And at this time, I would like to turn it over to Brett Bartlett. Brett, please go ahead.
Thank you, Kelly. Hi, everyone. Welcome to our webinar today. We're going to be talking about navigating wage and hour risks under the Biden administration. We have an hour. We could talk for probably days about this, but we're going to try to pack everything into a very short form summary. We have Q&A available. We probably won't be answering questions as we go, but if we have time at the end of our presentation, we'll try to get to a few. And if we don't get to your question, we'll try to answer them in follow-up. I'm joined today by an esteemed panel comprising Noah Finkel, Carrie Fredericks, and Scott Hecker. Each of them will say a little bit about who they are and what their practices are, but they really know what they're doing. I'm Brett Bartlett. I'm co-chair of our National Wage and Hour Litigation Practice Group. I co-chair with Noah and Carrie and one of our partners who's not here today, Andrew Paley. And I sit in Atlanta. I've got a national practice. I've spent the past almost 21 years focusing on wage and hour matters and preventing wage and hour cases and investigations if they're avoidable. But we'll share some of our insight. Next slide, please. We're going to talk about, with Scott, the Biden effect on FLSA enforcement by the Federal Wage and Hour Division. I'm going to cover how to respond to a wage and hour division investigation, which are getting a little bit wild these days. Noah is going to talk about 16B litigation trends. And so 16B is the provision of the Fair Labor Standards Act that provides for a private right of action for employees to bring lawsuits against their employers. And then Carrie, at the end of this, is going to talk about how to mitigate those risks by conducting an effective self-assessment. So let's move to the next slide, please. Scott, you want to take it away?
Thanks, Brett. Appreciate it. To briefly introduce myself, I am Scott Hecker, a senior counsel in our DC office. I joined Seyfarth in March 2020. To answer your unasked question, I have been remote this entire time due to the pandemic. Fun times. One day I'll meet these folks in person. That'll be fun. After about 12 years at the Department of Labor, I came to Seyfarth. At the department, I was a regional trial attorney, a national office attorney for the Occupational Safety and Health Division, and I also worked within the Wage and Hour Division in a couple roles, including helping to design and launch the paid self-audit program, and also serving as the acting director of strategic planning and performance. If we could go to the next slide, Kelly. So back in a December 2020 webinar, shortly after the election, we actually advised employers to expect an administrator in the Biden administration and a political team that was familiar with Dr. David Weil's research and strategic enforcement approach. Well, I guess no one's more familiar with it than Dr. Weil himself. As we see there, he's the once and future Wage and Hour Division administrator, returning back to the role he served in the Obama administration. And you'll see from his quote that he wants to send a consistent message through enforcement that persistent, egregious, and workplace-wide infractions will be met with significant consequences. So who's going to help him do that? Patty Davidson, who is in a deputy administrator role right now, was formerly the associate administrator for regional enforcement and support. She left to go perform a deputy role at the OFCCP. And then came back. And Jessica Lumen is the politically appointed the principal deputy administrator. So far, she's led the charge on rolling back Trump-era rules and guidance, and she'll be at the enforcement controls until Dr. Weil or another nominee receives Senate confirmation. So the SESs, the senior executive service folks, who are career individuals filling key associate administrator roles, many of them are fairly new to their executive roles, and a lot of them came up through the regions, in fact. And despite the strategic enforcement label that Dr. Wild applies to his approach, you may see some more flexibility in case selection, and that is sort of euphemistic from my time within the division. You could call it targeting freely without as much sort of data-driven case selection. Cheryl Stanton, who was the administrator under President Trump, she professed to favor clear processes and protocols for case selection and wanted to drive it with a data-based approach. But sometimes the regions kind of push back on that. It makes case selection a bit difficult. It makes hitting your metrics a bit difficult, and those are set annually. Each fiscal year, Wage and Hour goes through a process to determine, how many investigations we need to do in particular areas, how many, violative investigations we need to have, all those kinds of things. So the regions aren't always as on board with following the data. However, in a reorg, actually, in 2019, the division did stand up a enterprise and data analytics group that's headed by a new SES. It's a new position, so new SES. Brandon Brown, who heads that division, he's more interested, I would say, in using available numbers to predict where violations will be, as opposed to where they've been. So he's kind of a forward-looking person who will advocate to use more data. But I think, again, coming up through the regions, and folks like him and Mike Kravitz, who is actually the Associate Administrator for Performance and Communications, again, come with a regional perspective. And you could see Michael Kravitz using his background as the Director of Communications before he assumed this SES role to increase publicity, or again, to use the non-euphemistic term, public shaming of employers who violate the Fair Labor Standards Act. So as much as we may see some strategy-based and data-based enforcement, again, I think you could expect a bit more freewheeling targeting of employers. And one note, actually, leading into probably the next slide, is the fact that the Associate Administrator for Policy position has actually been empty since Mary Ziegler retired. And currently, Wage and Hour is rotating folks through that position. The policy team handles regulations, so it's kind of a big one to drive the ship on where we're headed. And we've already seen that, some examples of that, for example, with the independent contractor rule being rescinded. Groups have already filed litigation to challenge that. And you'll see, further action on joint employment. We've seen some of that as well. That's in the queue, struck down by a federal judge in 2020, October of 2020, likely to be rescinded. There's also been some activity around tip wages, how that will work under this administration, rolling back some, punting on others, but I'm sure we'll see some action around the 80-20 rule and potentially the tip credit generally. Another piece, obviously, as we alluded to, the independent contractor rule, something that's big on everyone's mind is how that will be addressed. We know Dr. Wild's position on it. We know Julie Su, who is still pending as the Deputy Secretary nominee, very focused on future of work in California. So there's a lot here to chew on. Also, the gig economy opinion letter indicating that gig workers are typically independent contractors has already been withdrawn. So that shows another direction that enforcement will go in this space. So there's also a lot going on, obviously, in the minimum wage area. The push by Democrats and President Biden for $15 per hour minimum wage. We've seen the executive order 14026 issued by President Biden setting the federal contractor minimum wage at $15 an hour. So, on that front, continue to look for it. That'll be rolled out early in 2022, the requirements on federal contracts. So start thinking about that and getting things in line now. And then moving into the paid and medical leave. We actually heard Secretary Walsh, I think last Monday, in a virtual meeting with some business executives and employees, suggest that, quote, the United States has been behind most of the world in supporting our workers in that paid leave, medical leave space. He referred to his childhood battle against cancer, where paid leave, he said, would have helped his family. And quote, our families and our businesses are paying the cost for this inaction. So it'll be interesting to see the push there. Obviously, there have been some competing proposals, and that's been batted around for a while. Then looking at equal pay, Massachusetts was the first state to overhaul equal pay, their equal pay law, and then Mayor Walsh partnered with the Boston Women's Workforce Council to implement the 100% Talent Compact, which was an initiative to close the gender race gap. So we've seen that kind of equity aspect to a lot of the Biden administration's activities, and I think we can see it here in FLSA and wage and hour enforcement as well. Something to keep in mind while looking into FLSA issues, DOL can also analyze prevailing wage issues under, for example, the Service Contract Act or Davis-Bacon and related acts. The reverse is also true. If we actually see the infrastructure package in some form come out and the Wage and Hour Division is tasked with enforcing prevailing wage laws, that could sort of have co-equal effect with Fair Labor Standards Act enforcement. So keep an eye on how those work against or with each other. And Kelly, if we could go to the next slide. So you're probably thinking this definitely sounds a lot like Bad Actors Beware, and you will certainly hear the term bad actor a lot more with the administration flip. Democratic administrations, and I served in both Democratic and Republican administrations, but sometimes they get a little bit lost chasing everybody, where the enforcement and deterrence activities could be better served by using the data we talked about earlier to actually pursue the most problematic employers. And I'm hopeful, though it's hard to say for sure, I'm hopeful that Brandon Brown and his team and the data analytics folks can really work to further the case selection, the database case selection, to determine where wage and hour should actually use its limited resources, not just thinking everyone is a bad actor, every employer is in the wrong, but really figuring out, for example, what is the model food service establishment that is most likely to commit a violation, and really leave good faith employers alone and try and work to identify who those are by following the data. I mean, we've already seen through sort of formal announcements and anecdotal experience the shift, and I think Brett and others will talk a bit more about this, particularly Brett with the investigation process as we've seen it. But within weeks, the paid program that I mentioned earlier was gone, so there is really no self-audit resolution at this point for FLSA enforcement. The division issued new guidance to its field staff on liquidated damages, broadening their use again, just as we saw under Obama. So we're seeing that again. And one thing also to keep in mind throughout, I think, is the increased enforcement budget that President Biden and the administration have asked for. Of course, these enforcement agencies like Wage and Hour need the resources to execute on their policies. They really are a dot on the sun versus the industries that they investigate. And without more investigators on the ground, it's going to be harder to execute these high-level policies. And I will say, actually, just in April, the Associate Administrator for Administrative Operations, which sounds super interesting and totally is, but it's basically the person who keeps the lights on and the trains on time-ish, for government level train running. She left the agency to head Job Corps after almost about 6 years. And that role's in acting status too. That's the person who kind of does all the budget work and deploys the resources and figures out what you need where. So to have someone in that role also be someone new to the game could actually impact enforcement as well. So there is, the on the ground enforcement is impacted by sort of these folks at the national office, and it'll be interesting to see how everyone kind of falls into place. But Brett, I'm going to segue over to you for chatting about the on-the-ground enforcement and the uptick in aggressive actions by our friendly neighborhood wage and hour investigators.
Yeah, thanks, Scott. That was really helpful, a really helpful overview of what's going on at the agency itself. The ground battle is heating up, and for anyone who's not been through a wage and hour division investigation, I think this will be a helpful section to pay attention to, because the aggressiveness with which the division is undertaking these enforcement actions, it's really increasing. And I think, one of the cool things about being at Seyfarth Shaw for me is I get to be surrounded by wage and hour nerds, and I consider myself to be a wage hour nerd. And I've been talking to my fellow nerds about these investigations, and without question, we all agree that they're being taken more seriously by the investigators, even in these first several months of the Biden administration. And we talk often about the fact that agencies like the Wage Hour Division, oftentimes when there's a change in administration, it takes a long time for change to happen. It's kind of like turning an aircraft carrier. But for whatever reason, we're seeing immediate changes on the ground with these investigations. So let's go to the next slide. We often get the question, why did this investigation start? What happened to me? And after we talk about that, we'll get into the nuts and bolts of these things. But usually we will either see an employee complaint, or we'll see what the investigator will say is kind of a random investigation. I think there are rarely random investigations. I used to think about these investigators driving down the road and seeing a road sign for a store and saying, hey, I think I'm going to go in there and start an investigation. And that's really not how it's happening these days. Normally, there is a targeted reason or a directed reason, if not an employee complaint. So we're seeing a lot of investigations in businesses that use independent contractors at present. We're seeing a lot of investigations into logistics and transportation businesses. We're seeing still a lot of investigations into other types of employers that have many lower wage earners, so hospitality, restaurants, and that kind of thing. The interesting thing about the employee complaint initiated investigation is that the investigator will almost never tell you that it is in fact an employee initiated or a complaint initiated investigation, and they certainly won't tell you who the employee was who initiated the investigation in the event that that's what started it all. Let's go to the next slide. So just so you can kind of acclimate, when an investigation starts, there will be a request for information. I'll show you a sample of one of those in just a second, but these are the types of information that the investigator will request. And if you look at it, especially if you start thinking about the payroll records and the employees, number of employees that you have, as you start thinking about things like the names and addresses of the owners and officers, tax records for 3 years to demonstrate annual dollar volume, organizational charts, employee phone numbers. Wow, it gets really overwhelming very quickly. In my experience, almost no investigator actually needs or wants all of this information. There's almost always an easier way. There's almost, for example, the reason that generally speaking, the investigators ask for tax records demonstrating annual dollar volume going back 3 years is so that they can establish coverage. And you can stipulate to coverage generally and avoid having to produce that. Phone numbers, I always think about the fact that I wouldn't want to be an employee getting a call out of the blue from an investigator. Well, the regulations don't actually provide that phone numbers are something that the investigators can get. So there's all kinds of ways to think about these information requests. If you're subject to an investigation, take a deep breath, talk to an expert, and figure out what you actually need to respond with. And usually some conciliatory discussions with the investigators will help you to avoid having to produce it all. So let's go to the next slide. And just so everyone knows, it sometimes takes just a minute for the slides to catch up to our presentation. So please forgive the stall. This is a sample letter that an investigator sent to a business back in 2015. And the print might be a little bit small for you to read. You'll receive a copy of this presentation and follow up to the webinar, so you can take a closer look. But this is pretty standard in terms of the types of information that's requested. Oftentimes you'll see immediately where that blank is and where there's a time. I will visit your establishment on blank date at blank time. And the investigators will expect you to be available at that time. You can almost always push that date back. But these are the types of information that people are requesting. Let's go to the next slide. And these requests are on fire right now. One of the things that's been remarkable to us recently is that in addition to all the language that you'll see on that sample letter that I just showed you, at the bottom it'll say that you have to respond to this request within 72 hours. And we've had federal investigators recently saying, if you don't respond to us in 72 hours, if you don't start pulling these documents and getting them over to me, and we've actually had one say, you have to get me everything that I've requested within 72 hours, then I'm going to initiate a subpoena action and I'm going to come after you hard. There will be adverse inferences. There will be all kinds of bad things that are going to happen. Again, take a breath, realize that these investigators are looking for ways to put pressure on to employers to get them to respond quickly. We've, in all instances, been able to talk the investigator back, discuss what's actually necessary, and to avoid any kind of bad ramifications because we're not prepared to respond quickly. But if we go to the next slide, it's really important to have a plan for responding to these things, because you can imagine if you're a multi-unit operator, you've got someone out in the field, at a store, at a branch office, whatever it might be. Here comes an investigator on site, or by fax or email, you get this letter saying that I'm going to be there and you have to respond in 72 hours. If someone's not acclimated to that process, it sounds important, it sounds dangerous, and they're likely to start responding. They're likely to start pulling records. You've got to have a plan in place, and this is really before first contact with an investigator. We recommend that you have a plan for who's going to respond to any approach by an investigator, what the next step is going to be, who does the information requests get escalated to, who's going to be on standby to help coordinate any response. And so who's responsible for enforcing the plan that we've put in place? You've got to make sure every single location understands what the plan is. Because again, if you've got an investigator showing up and they're nice as pie, they'll come in and they'll say, oh, we just need to look at a few records. So if you can start making copies of payroll records and all your employee census and just hand that over to us, we're going to be just fine. And we've seen it time and again where that's what happens. And suddenly you've got all kinds of records that are going out. You don't know what's been produced. And so you need to have that plan. Consider having outside counsel involved. Sure, that's a plug for us, but it's a plug for anyone who knows what they're doing around these things. Because I've found, generally speaking, when I get involved with an investigator and I say, hey, I've been through this before, my job is not to impede, my job is to actually facilitate, they actually say, I'm glad you're involved, because now we can actually cut to the chase of what we need. But in terms of preparing, make sure that you have a wage hour compliance plan. Who's in charge of making sure that you've got compliance across your operation? Who's in charge of exemption reviews? Who's in charge of auditing time records and pay records to ensure that they're accurate? Who's in charge of making sure that the behaviors of the sites are not leading to off-the-clock work? Do that kind of self-assessment. Consider what's going on both with your hourly workers and also with your workers who are not classified either as employees, so they're independent contractors, or they're classified as exempt. So let's go to the next slide. So what you'll get immediately that first contact letter saying that there's going to be an on-site, and you need to ask for more time, whether it's through counsel or whoever has been put in charge of responding initially. Then think like an investigator. Do a quick review of your time records and your attendance and payroll records. See what red flags pop up. Take a look at any complaints or issues that have come up before. Start to think about your exempt classifications. Do you have a bunch of exempt employees relative to the non-exempt employees? Those are red flags. If you have exempt employees who are making approximately the same wages as hourly employees, that's a red flag. So what would the investigator be considering looking at? Consider whether you have anyone who's working for you who is under 18, and look to see whether you've got any compliance issues around that. And consider too that the wage and hour investigator is going to ask about your FMLA policy. He or she will want to see it. And they may, to Scott's point, start looking at the Service Contract Act and Davis-Bacon Act compliance. So let's go to the next slide. Investigators are not all cut from the same cloth. Different levels of experience, different administrations that they came in, different biases in place, different levels of aggression. There are certain regions of the country where if I'm defending an investigation, I'm going to know that I'm going to have to hop to and rush. And they're going to be taking very aggressive positions and presuming that my client's out of compliance. And some of them are very strict. Others are not. I mean, others are very low key, kind of let's do everything that's right. Let's get money if there needs to be money gotten for employees, but let's make sure that the business is in compliance. Almost all the investigators push for speed. They try to put pressure on you to move fast. Almost all of them start with very broad requests, and as I mentioned, most of them are nice as pie, at least at the beginning. Let's move to the next slide, please. At present, many investigators are still working remotely. And that was a bit of a game changer. They will have their opening conference by video or by telephone. All the interviews that they conduct will be done remotely. Some are starting to revert to in-person. The opening conference is when they come in, flash their badge if you're in person, and tell you what they do and ask you preliminary questions. They may want to conduct employee interviews, whether it's in person by phone. Sometimes they will place phone calls before you even know that there's an investigation. They may send out mailers to employees asking them questions about their jobs. And then as the investigation rolls on, usually the investigator will preview for you what his or her findings are going to be. And at a closing conference, that's the opportunity for them to tell you whether you've come through with a clean bill of health or whether there are going to be extra issues. And if we go to the next slide, we've got the ramifications here. So best result, obviously, no findings of violation. Worst results could be back wages, liquidated damages these days, or civil money penalties, which are in addition to back wages and in addition to liquidated damages, usually for repeat offenders. They may ask or suggest that you do a self-audit. So I've had a situation recently where only one location was implicated, but the investigator told me that probably she suspected that there were issues at other locations. And Brett, you really should ask your client to go out and confirm that they're in compliance everywhere. They can expand the investigation, and sometimes that does happen. So going from that one location to all locations. And under 16C as opposed to 16B, the Secretary of Labor can bring litigation, and it's a representative type of action. So the worst case, in my view, would be that back wages, liquidated damages, and civil money penalties, and there can be parallel 16B private litigation alongside that. Next slide, please. Just to get you used to terminology, and you'll be able to see this when you get a copy of the presentation, so I won't go into all the details. At the conclusion of an investigation, if there are back wages to be paid, the WH-56 contains a summary of all the back wages that need to be paid and to whom. The employer has to sign that, confirming that it will comply with the law going forward. In exchange for paying back wages, the employer can collect a WH-58 receipt for payment of back wages from employees. It contains a release that goes back. It covers the period that was covered by the investigation, both back wages and liquidated damages. So it's a really valuable piece of paper to get if you're paying back wages. And then there will be instructions provided about how to make back wage payments, the timeline for doing so, and a coordination around that. Next slide, please. And this just kind of summarizes the final steps. You need to think about how to distribute the back wages. The Wage and Hour Division will provide an explanation, instructions for doing that. They will suggest that for former employees, for example, you should send out checks along with the WH-58 to be returned. I think that it's important to have a communication plan around all of this, and would be happy to discuss that with you, as would any of our specialists around this stuff. They will introduce a representative of the Wage Hour Division who is responsible for coordinating the collection of any unpaid amounts. If there are amounts unpaid because someone could not be located or because they didn't cash their check, usually that amount will have to be paid over to the Department of Labor, and eventually will issue to the U.S. Treasury. And then I mentioned 16B litigation. I've got a situation right now where there was an employee complaint. DOL or Wage Hour investigated the location, found that back wages were due to about 30 employees. The back wages were distributed. and one of those employees nonetheless went off and filed a 16B private litigation in another state. And so you need to be aware that that can happen, and then you have to be prepared to deal with that. So that's my last slide, and I'll turn it over to Noah.
Thanks, Brett. For those of you who don't know me, I'm Noah Finkel. I'm in Seyfarth's Chicago office. I'm a co-chair of the Wage Hour Litigation Practice Group with Brett, with Carrie, and our partner Andrew Paley as well. I've been doing wage hour counseling for quite a while, and I've been litigating them primarily, is what I do, for now 26 years. So it's been a while. In fact, when I first started doing this kind of work, there was very little litigation in this area. Most of what we did was ensuring our clients were in compliance and working with the Department of Labor. But as everyone's painfully aware, 16B litigation has shot up considerably in the last 20 years, and it is now extremely prevalent. So that's what we're going to talk about today. So if we can go over to the next slide, please, Kelly. The change in administrations don't affect litigation in the 16B context directly. You know, that's a totally different branch of government. It's the court. But it does have an impact. First of all, it of course sometimes what the Department of Labor is talking about reflects what's going on in the courts, but also what the Department of Labor talks about causes things to be filed in courts. For example, in 2004, we saw for the first time in 40 some odd years, new regulations discussing who's exempt and who's non-exempt from the FLSA's overtime requirements. That kicked off a huge spike in private collective actions filed challenging exempt status. So the change in administration matters. It has a big indirect impact. So what do we think is going to be litigated in the courts in the next 4 years? I think they fall into three buckets. The first one is what we've been dealing with all the time, which are exempt status and off-the-clock claims. These are going to continue to be the most prevalent type of claims that we received, and we'll you know, for the most part, at least for those who work in brick and mortar locations, we don't expect there to be a huge change in this. But where we do expect to see some changes are in the other two buckets that I've got on the slide here. The first is what's going to continue to trend upward. And the first one I have here is regular rate. You know, this is, are you including all the elements of compensation in an employee's regular rate when overtime pay is calculated? And this is an area that's been trending up lately, and we expect to see that to continue, largely because it is incredibly low-hanging fruit for plaintiffs' counsel. Well, not incredibly juicy fruit, because the dollars aren't often as staggering as they can be in off-the-clock or exempt status cases. They are extremely easy to certify, involve very little discovery, and thus can be brought in an incredibly easy way by the plaintiff's bar. So a lot of lawyers are filing these all the time these days. The other two areas that all of us have seen, and we think will continue to be seen even more, are independent contractor classification and joint employment. By joint employment, what I mean is that there is an alleged underlying violation, and a second company is being brought in as a putative employer of the employees. And we're going to talk about that a little bit. Scott did a little bit earlier, noting some DOL activity in that area, and I'll be touching on that in a little bit. The third bucket is what we think is going to increase. And this is largely a result of just what's going on in the economy right now. You know, we expect there'll be a couple of things. One are the compensability of health screenings when people are coming into work, or temperature checks. No surprise that this would happen. Fortunately, this looks like it will be kind of a fleeting area where most companies aren't going to be doing it for terribly long, as a very high percentage of their workforce is vaccinated. But the two areas that we think will continue for certain are going to be claims for off-the-clock work from those working from home, or claims from those who are doing part from home, part in the office. And there may be issues about whether their time spent going from one location to another is compensable. There's a whole, as work becomes more remote, which was happening before COVID, by the way, but COVID is put on steroids. The FLSA just doesn't fit perfectly for that. And any time you get the law not fitting in exactly with what the economy is doing and the way work is being performed, you get a lack of clarity, and lack of clarity breeds litigation. Kelly, can you please go to the next slide? What I'd like to turn now to are those two areas, two big areas where we think the upward trend is going to continue. And this will have, and where this comes from is from a number of areas, but as we all know, the gig economy and a lot of increasing use of contingent workers have shown a very bright light on how companies classify employees as employees or as independent contractors. And so there is a lot of attention now, both in the courts and at the DOL, on how we define the employment relationship. It's interesting here because you'd think with this big area of litigation that the FLSA would define who is an employee and who's an independent contractor, but it's nowhere to be found in the statute. And in fact, there's not even a regulation on it. There have been opinion letters, there are fact sheets. There was for a time an administrator interpretation that David Weil, we talked about earlier, promulgated, but that's since been withdrawn by the Trump DOL. But that was all we got from the DOL. And as a result, we had courts using various versions of balancing tests, usually under the guise of the economic realities test. And the economic realities test, really, what is it? It all depends on what circuit you're in. It involves a balancing test of a number of factors, which courts weigh in with different ways, and which the various prongs are defined in different ways by the courts as well. And many times you could look at a particular situation and really just flip a coin as to what a court would do, because it really depended on where you got sued, what judge you drew, and how that judge wanted to weigh those various factors. Without guidance from the DOL, this was really a hodgepodge. The Trump administration did try to provide a regulatory definition. It would be interpretive, by the way, and it did have a final rule issued in early January of this year. But of course, there was a change of administration, and the Biden DOL quickly delayed the effective date of that. It was supposed to go into effect on March 6th, but the DOL delayed the effective date of it so it could think about it more. And it ultimately withdrew that guidance on May 6th of 2021. The earlier guidance, by the way, would have made this test a little more clear. It was going to focus on really two factors, one being how much control does the worker have over their work, and second, how much opportunity they have for profit or loss. And the various other factors that courts traditionally have weighed would be something that you turn to only if those first two factors don't point strongly in one direction or the other. They would be used only in the close cases. This would have been a much simpler analysis, but it's gone. It really is a dead letter at this point. So courts cannot turn to it. So we're likely going to see some new guidance. Again, this is going to come from David Weil, and he's going to focus more on economic dependence. It likely will result in more workers being defined as employees and thus being covered by the FLSA. We don't expect it to be a disaster like the ABC test because everyone seems to recognize that for the ABC test to apply to the FLSA, there'd need to be congressional legislation about that, and the odds of that are very slim. So what we're likely to see is something very similar to the administrator interpretation focusing on economic dependence that David Weil instituted. I don't know what form that will take. It's unlikely to take the form of opinion letters because those have never been favored by Dr. Weil when he was wage hour administrator under the Obama administration. He issued none of them. So it likely will come in the form of either an administrator interpretation or could go through rulemaking. And then at that point, it's going to be up to the courts in 16B litigation to decide how much they want to defer to that. And we'll get to deference in a little bit. So if we can go to the next slide, please. The other area where we look for how the employment relationship is defined is joint employment. Again, to what extent is a second company deemed liable for the FLSA violations of another? You know, and here again, we don't have a statutory definition of what joint employment means. We do have a rather vague regulatory definition that courts really don't tend to look at because it's fairly meaningless. And so again, we have courts defining this in various ways. We did, similar to the independent contractor sphere, have an administrative interpretation under Dr. Weil, but it was withdrawn by the Trump administration. The Trump administration did have actually a rulemaking in this and issued a fairly comprehensive interpretation that it promulgated starting in 2019, went into effect in 2020. That, however, was enjoined by the Southern District of New York, largely because that particular district judge believed the rule ignored the FLSA language and prior precedent without an adequate justification. That was appealed by the solicitor's office up to the Second Circuit. And so there is an intent to try to reverse that had been expressed by the DOL. But now that there will be new people in charge of the DOL's briefing on this subject, and that brief is due by the end of this month, by the way, we expect that they will probably throw in the towel on this to some extent. And you know, we particularly believe that because the department has announced that it's going to roll back this rule. It's currently enjoined anyway, so it technically isn't into effect. There probably will be a new interpretation that's going to be broadened and wrap more putative employers into FLSA litigation. So our advice here is take a look at your indemnification provisions with other companies whom you procure employees and make sure that those provisions provide you the protection that you think you're going to need, because there is a strong chance that if you are using employees at your, using workers at your work site that are brought to you by, an agency or staffing agency or just another company, you'll be roped into that case as well. So let's go to the next slide, please. So we talk a lot about the Department of Labor because that's how the Biden administration will affect 16B litigation. But how much what the DOL says will matter? That may be eroding. I mentioned earlier the injunction of the joint employer rule by a district judge in New York. We saw an injunction 5 years ago when the Obama Department of Labor attempted to substantially increase the minimum salary for exempt employees. And ultimately that was rolled back, and the Trump administration instituted a more modest increase of that minimum salary. But it is pretty rare for any agency's rules to be enjoined, but it has happened twice with the Department of Labor in the last couple of years. Moreover, we have seen an increase in courts not following what the DOL says when they have mere interpretive regulation. There are some tip credit rules on side work that a mass of district courts have refused to follow. And just 2 weeks ago, an opinion letter was issued about how delivery drivers' expenses are estimated in determining how much they need to be reimbursed for minimum wage compliance, be rejected by a district court. And this is really, compared to, for how long I've been doing this, I have never seen this rate of district courts disregarding what the DOL says in various forms. And I think that's for a few reasons. I mean, first of all, there's just more litigation now, so of course there's going to be more opportunities for district courts to not follow the DOL. But I also think that courts are becoming more conversant in the FLSA as they gain more experience with it. The plaintiff's bar is getting better at it, and they're making stronger arguments for why the DOL should be disregarded. And, you know, we're now kind of getting to the point where the rules in these areas are becoming dependent on what party controls the administration from which these rules emanate. And when courts see flip-flopping, they become more likely to reject these rules. And we expect that probably will continue in the next administration. So, you know, the DOL may say something, but it's going to be an open question on what courts will do with that. If we can go to the next slide, please. I've talked a bit substantively about how we think collective action litigation is going to go under the Biden administration. I want to note briefly how we think it's going to change procedurally. You know, and this is an area where what the Biden administration says probably won't have much impact, but these are broader trends of which we all need to be aware. The first is that you know, first we've got some good news, at least potentially good news, which is that, you know, for a long time, collective action litigation has all gone the same way, with a two-step process under which the conditional certification stage it has been governed by something where the plaintiff only needs to make a modest showing to carry a low burden to satisfy a lenient standard for conditional certification. And they note that, you know, we're not going to consider the merits now. This is all pre-discovery, so let's just let everybody know about this lawsuit and invite them in. And in fact, last year, 84% of conditional certification motions were granted, a huge percentage of them. Of course, the defendant then has the decertification stage where it can try to decertify the case, but you know, at that point, hundreds of thousands of dollars have been spent, and the settlement pressure from that can be hydraulic. The Fifth Circuit became the first circuit court to reject this approach, and you can see on the slide here what it put in its place. The bottom line here is that it's going to scrutinize the merits of a case and just and allow much more discovery before sending out notice. And so this would result in a much lower percentage of cases getting conditionally certified. It would cause the plaintiff's counsel to have to do a lot more work at the get-go in order to get their case certified, work which, in our view, often won't be able to be done successfully by them. And what remains to be seen is how, you know, what other courts will adopt this approach, because there is quite a bit to be said about it, because the current one is very inefficient. It almost always leads to conditional certification and then a lot of discovery and FLSA collective actions being in courts for several years before they can get to the decertification and summary judgment stages. If we go to the next slide, please. You know, the other area is that we might see a limit on how easily nationwide collective actions can be brought. This emanates from a Supreme Court case from 2017 called Bristol-Myers Squibb. I won't get into the jurisdictional details, but we're seeing the extent to which this applies to FLSA collective action issues. And there actually is, just in a couple weeks, going to be oral argument in the Sixth Circuit on this issue in a case where Seyfarth is representing the defendant. A favorable decision here could very much restrict the ability of a plaintiff's lawyer to maintain a nationwide collective action against employers unless that case is brought in the principal place of business for the employer. And then if we can go to the next final slide, please. There is a little bit of bad news here, which is that, you know, on the procedural front, which is that, you know, despite what's going on with collective actions, we have seen the plaintiff's bar become far more sophisticated in finding a mass of plaintiffs before they even file a case. They're using social media very effectively to locate people they think would be in their collective. And oftentimes when they file their case or shortly after they file their case, they have dozens, if not hundreds of people signed up. So the whole certification process at that point doesn't matter all that much. They've already got a big case against you. The other area is that for the last several years, employers have been able to use arbitration agreements with class action waivers to not have to face collective actions or class actions. But there is legislation that would peel that back. The Biden administration favors the FAIR Act. It's likely to pass the House. The PRO Act, which contains similar provisions, already has passed the House. But we view all these as probably unlikely to pass the Senate. And then finally, for those who do have arbitration agreements, we're seeing plaintiffs' counsel using those same social media methods to find several people to file hundreds, if not thousands, of arbitrations against the company at the exact same time, which can be crippling. So with that, what I'd like to do is turn this over to my partner, Carrie Friedrichs, to talk about how to mitigate a lot of these risks.
Great. Thanks, Noah. As Noah just mentioned, my name is Carrie Friedrichs. I am a partner in our San Francisco office. I spend about half of my time litigating wage and hour cases and about half of my time trying to help clients avoid litigation. So in this next section, I'm going to just discuss some of the recommendations that we have for conducting an effective self-assessment so that you're prepared in the event that you do face litigation or a DOL investigation, as many employers do at increasing rates on both fronts. Next slide, please. So what can employers do? The first thing to consider is, how is the DOL and how are plaintiffs' attorneys going to view your practices? How are they going to examine the data and your policies and all of the relevant factors underlying your wage and hour practices? The first step really is to assess your policies and your practices, prioritizing those practices that really present the most legal risk. So many of those areas we've discussed already today, but those are constantly evolving based on the priorities of the administration in the DOL context and the types of claims that we're seeing from the plaintiff's bar, which are always changing. So really keeping a focus on what kinds of cases are being filed and making sure that your practices in those areas are compliant and address the theories that we're seeing from plaintiff's attorneys. The second step is to fix your policies if you find any that pose risk, doing so in a way that avoids highlighting problematic past practices is ideal. Also, there are employee relations considerations to keep in mind. And then also for employers with unions to contend with, there are the bargaining obligations that can sort of extend the process and complicate the process of fixing some of the practices. The third step is to make sure that you train managers to follow the policies that you have fixed. Oftentimes, policies are rolled out in an improved way, but if nobody knows about it and nobody has been trained on it, and you're not able to document that you've notified the employees about it, that can be problematic. And fourth, a very important step is auditing for compliance and really considering your audit tools and the best approach to auditing is critical. Oftentimes, there are tools just basically ready to be used that can be very effective in evaluating whether your policies are actually being implemented in a way that is effective and is the way that they were intended. Oftentimes, timekeeping systems have auditing features or report features that you can use to see what's happening. Are employees being scheduled for their meal breaks in the way that we have intended that they be scheduled? Are we seeing pockets of non-compliance for different groups of employees? So there may be tools that you have already available that can really facilitate your ability to audit your practices. One thing that is important to note is maintaining the privilege of that audit is important. And in particular, making sure that legal is involved and is directing the work, and that when you generate audit materials, somebody follows up on them. You just don't want to generate materials that are that reveal a problematic practice and then not take steps to address those issues. as that basically can just create evidence that is helpful to plaintiffs in litigation. And another point that is very important in terms of training and affirming the messaging is to take additional steps to promote a compliance culture among your managers by motivating them to comply with your wage and hour policies. There are many ways to do this. Really messaging to the managers that this is a priority of the company and that we value this is important, but also you can build in other incentives like making wage and hour compliance part of a performance evaluation or creating financial incentives for managers who achieve compliance goals. Next slide, please. So now I'm going to talk through some of the topics that we see kind of most frequently drive wage and hour risk. The first is timekeeping. Taking a look at how time is recorded for different groups of employees is a very important part of assessing whether you're going to have an off-the-clock issue. And oftentimes we see that there are timekeeping practices in place that have been set up over the years with assumptions that the work is being performed in a certain way and that all time will be captured. So it's really important to see if the way that time is recorded by your employees is continuing to capture all of their work. Another step is to look at, do you have rounding or grace period policies in place? Sometimes employers think that they have a non-worked grace period in place, which is very different from rounding of actual time worked. But then when looking at practices, it turns out that local groups or employees are actually working during the time that they're supposed to be in a grace period. So making sure that that is not the case is important. Looking at auto-deduct practices for meal periods, that's a very common claim where we see just automatic 30 minutes deducted from each employee's time record for the day. Making sure that if that is actually occurring, that there are practices in place that support that that deduction is proper is very important. Our meal periods rounded, we have a new bad California Supreme Court decision on that topic. So consider stopping that practice, particularly if you have employees in California. Attestations are also can be very helpful, and those are oftentimes built into the timekeeping system. So utilizing those features when they're offered can really help focus employees on their pay and their hours and ask them to affirm that they agree with that they've been paid properly, that they've recorded all of their time, and that they've received meal and rest breaks in states where that's required. One thing I just want to note, I know we just have a few more minutes now, but considering some of the different types of off-the-clock claims that have led to recent litigation is very important. One is mobile devices, making sure that employees who carry mobile devices or are reachable on mobile devices are paid for that time when they are contacted outside of regular work hours. Also making sure that you look at security check procedures, bag check procedures in California, and then other types of COVID screening, as previously mentioned, and other types of off-the-clock work that may be occurring routinely. Next slide, please. Regular rate of pay is, as previously mentioned, a very common claim that we're seeing. So the key message here is look at your pay codes, look at how they're configured. This is a very, very easy claim for plaintiffs' attorneys to bring. So just making sure that bonuses and differentials are all built into the overtime rate correctly, and that rate is being paid correctly for all overtime hours worked and for all other rates of pay that must be paid at the regular rate of pay. In California, for example, that rate must be paid for sick leave as well as overtime. So we're seeing many claims in that area. So making sure that that code is properly configured is very important. Next slide, please. Incentive plans, we see fewer class type claims dealing with complex incentive plans, but oftentimes there are other types of incentive plans involving piece rates or production bonuses that, that also present risk. So really, the slide kind of outlines some of the key issues that to consider in connection with incentive plans, making sure that the criteria for earning those incentives is very clearly documented in the policy or the agreement, making sure that if you ever want to get the incentive back once you've paid it, that that's built into the earning criteria, and making sure that the plan clearly specifies what happens at termination. Next slide, please. An exempt classification is another topic that we always have seen driving litigation. Just the message here is really just look at your job descriptions. If they don't document the exempt tasks that the employee is performing, make sure that they do. And then make sure that your salary levels are adequate to meet the new tests. In California, it changes every year, and you know, some state laws also have salary minimum requirements to keep in mind. Next slide, please. And we kind of covered this one already. Independent contractor and joint employer relationships are really going to be issues that we're going to see pushed to the forefront of litigation in the next few years. So really looking at your relationships, making sure that you've documented to the extent that you can indemnification provisions within your agreements with contractors and vendors and staffing agencies. And consider the benefits of looking at the practices of staffing agencies and other vendors who have large numbers of workers on site, just because while that may involve some more control, it also puts you in a better position to ensure that they are complying with the law, and that if there is a finding of joint employment, those practices won't pose an issue. Next slide, please. And now I will conclude with the CLE code. It is SS8821. And I'll turn it over to Brett.
Thanks a lot, Carrie. Thank you, everyone, for attending. Most of you who attended because you received your invitation to join us in part because you already requested a copy of our FLSA handbook. For those of you not familiar with this, please take a look at it. Contact us if you'd like a copy of it. There's all kinds of great compliance stuff within it. In the appendices, there are audit checklists for exemption reviews, for off-the-clock reviews, for independent contractor reviews. There's guidance about how to conduct an audit. It's a really valuable resource, so reach out to us. You should be receiving, as a matter of course, the presentation that we just provided because you signed up for the presentation. But if you'd like to get a copy sooner, feel free to reach out to any of the four of us, and we'll be happy to send you a copy. Our contact information is here on this last slide, which we'll leave up for a little while. Sure to appreciate your time today. I know we ran just a little bit over, but we'll look forward to seeing you the next time. Thank you. Take care.
This concludes today's webinar. Thank you for attending.